some special rules for small business, and I'm going to cover those very quickly, and again, oversimplifying. It changed the level that a small business was defined, and 15 employees or less, and it's a complicated formula that depends upon the day and the head count and a variety of things, and I'm not going to go into that this evening. But 15 employees or less is generally a small business. It introduced, or it reinforced, perhaps would be better to say, a two-tiered qualifying period. You might think, well, what's the qualifying period? The qualifying period is of vital importance if you're looking at people who have been employed in an organisation, you're considering dismissal. If they've not served the qualifying period, they don't have a claim. It's as simple as that, at least in terms of unfair dismissal. The qualifying period is two-tiered. Firstly, if it's an employer of greater than 15 employees, the qualifying period is 6 months. So if you're a 30 employee firm, you've got someone who's been employed for 6 months, 7 months. If they're dismissed, they've got access to a claim for unfair dismissal. But you're a small employer, you've got 12 months worth of qualifying period. Very important. Simply, if they're dismissed in the qualifying period, and I saw someone recently who was dismissed on the eve of their 6 months. Anyway, we eventually came to the conclusion, for a variety of reasons, they simply didn't have a claim for unfair dismissal. But I'll flag this. As well as unfair dismissal, there is another concept called unlawful termination. Unlawful termination is where someone is terminated on what are regarded as prohibited grounds. Now, prohibited grounds are illegal grounds. Now, they're grounds, and I'll oversimplify this again, which include race, sex, sexual preference. If you have someone who's terminated for reasons that can include those reasons, even if they're in the qualifying period, they may have a claim for unlawful termination. And the Small Business Fair Dismissal Code was introduced. I'll talk briefly on that, and this is the last topic I'm going to talk about this evening. Firstly, it sets out some aspects which were part of the previous law, but it sets them out in a reasonably straightforward way. It provides that you can dismiss someone without notice for what's regarded as serious misconduct. Serious misconduct is defined, and it's defined to include some things which has always been the law in Australia, but theft. If you've got someone who has been suggested, perhaps I need to be a bit more careful about this, who it's been suggested that they've thieved, and if that's proved, then they can be dismissed without notice. There's a variety of other categories which are set out in the code. That's not radically different from the law in Australia, but it is set out. The code also provides this: if you dismiss people, you must have a valid reason. That's not a particularly high hurdle, but it provides that if someone is being dismissed and it relates to poor performance, they have to be given an opportunity to rectify the problem, and they have to be pointed out. And the code's interesting, it says preferably in writing, doesn't necessarily have to be in writing, but preferably in writing, they have to be pointed out that he or she risks being terminated if there's no improvement. And then, as you'd expect through common sense, they have to be given an opportunity to see if they can improve. And the code introduced a checklist. Before I close, there are 3 documents which I'm going to mention to you. The first is the Fair Work Information Statement. Accounting professionals, being the thorough people that they are, have already provided you with that. Howard will cover this in his presentation, I'm going to guess. But that's one of the key documents, particularly when you're employing new staff.